Fast forward, you need more China so AGH Politics Avenue. Political stories are trending because making headlines. And a gym ready to be Akroma ni di on Brasima. Best say you mo imra yung simu ye ko yung simu. Chief Justice a free akunya so Justice Torkornoo meno ka say ni se kunin sayam se Omanpanyin ensa mana kunya no na onsan enkoye adwuma e Supreme Court say Supreme Court judge na we see in the fiamako ene miracle abwaje spokesperson ema Dr. Bawumia attraksi na asemi omudomu esuko mesrekse yemunwram peniapa onye sa kunya no na se bibi pote ebetimi atwena sign
to be looked at again, because constitutionally she's entitled to remain as a judge, even though the procedure was to, or the processes that led to her removal was in respect of her position as CJ. That is untenable. That is not the constitutional architecture that we have. Our constitutional architecture is the effect that the CJ sits in a composite capacity as a judge, as well as head of the judiciary.
Dual roles.
And therefore, where your activities of your administrative functions have been called into question and leading to a petition resulting in your removal, it also affects your role as the judge, because it goes to the propriety of being eligible to sit or to be fit for purpose as a judge, judge. And this is not the first time this matter has come before the courts or engaged the courts in these issues. 30 years ago, the Ghana Bar went to court to, as it were, get Justice Abba removed. And in the course of the preliminary objection raised by the then Attorney General, the court upheld the preliminary review, but in the course of writing the ruling, the reasoning behind the ruling, people like Pega made this very important dictum that should guide us. It was of the opinion that the processes that was before them, if it succeeds, it will lead to the removal of the Chief Justice, not as mere Chief Justice, but also as a judge of the Supreme Court. Then again, in the matter of Ajechu, Justice Dateba went to town. He actually exploded.
So you refer to a first one 30 years ago.
Yes.
You refer to a second one, which
in
was
fact,
in
10 years after.
2006.
2005, 2006. 10 years after, Ajechu went to court. And to challenge the contents of the petition leaked, that's Bright Akwete's petition. Again, the court took the trouble to explain that if the processes succeed, it will lead to the removal of the Chief Justice as well as a judge of the Supreme Court. Then finally, CJ's own case, her own case, one of the cases she took to court a couple of months ago, Justice Amadou Tanko, he reasoned this way, and this on page 26 of 32 of the ruling, of the judgment of the court. He said, as part of the conclusions, the above observations provoked by paragraph 12 of the applicant's affidavit aside, I need hardly say that I arrive at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge one way or the other. So this is a beaten path. It is settled. There's nothing to be determined otherwise. Yes, it's right. You see, because the propriety of your conduct as a superior court judge, which may lead to your removal as a basis of a petition questioning same, is the same as the propriety for the removal of a court of appeal judge, of a high court judge.
But the argument she makes is that in Article 146, if you want to remove a superior court judge, you use Article 146 Clause 4. But if you want to remove a Chief Justice,
yes,
you use Article 146, Clause 6. So why do you use 146, Clause 6 process to remove her and then come to argue that, and you issue a warrant under the hand of the president, and you issue a statement also signed by Dr. Callistus Mahama, and you say you have been removed as Chief Justice and a judge?
Yes, because
when you use only one procedure, not the other procedure.
Because the procedure in 1464 is in respect of a superior court judge, which could be a high court judge. That was not the terms of the petition that came before the president. It was a petition against the removal of the CJ. And you can't be a CJ without necessarily first being a superior court judge. In this case, a Supreme Court judge. And Article 128(1) is very clear. The Supreme Court shall consist of the Chief Justice and no less than 9 other judges of the Supreme Court. You are the chief of all the judges.
The Chief Justice is actually a judge in all the courts.
In all the courts. That's our constitutional structure. So you are actually the chief of all the judges. So when your conduct has been called into question, that leads to your removal as the head of the judiciary. There's no way you should survive.
The Chief Justice is an administrative role.
No. The Chief Justice is not merely, that's only one part. The other part is that you're also a Supreme Court judge. You actually empanel the court and you sit.
That's an administrative role.
Yes. But you hear decisions. You deliver judgments. So you can't say that where your functions as an administrative arrowhead is called into question, has been determined, pronounced upon, as being a basis for your removal, we should not allow you to sit as a judge. Because it's the same grounds. In fact, if you take the code of conduct for judges in this country, a breach of one of this code to lead to the removal of you as a CJ. Just a breach of this one code.
Yeah, so the argument is not about the CJ.
The argument is about the fact that she's trying to decouple herself from her role as a CJ.
Is it true that she performs dual functions?
It is true. That is the Constitution.
Okay.
The Constitution says to be a CJ,
Clara,
you perform dual functions. You sit as a judge.
Clara, help us. Do you subscribe to that kind of argument? That we go to Pegan's pronouncements, as he said some 30 years ago. Then we go to Ejechum 2006. Then we come to Databa Modibo Okran, rather read Modibo Okran, and so on. Yes.
For me, I would go back to the constitutional architecture.
Okay.
It provides the grounds for removal, whether as CJ or as Supreme Court judge.
Separately.
No, the grounds are the same for both.
Okay.
The grounds are stated misbehavior or incompetence or ground of inability to perform your office. It is the procedure that is different. Because if it was a Supreme Court judge, you would have to refer the petition to the CJ to make a prima facie case. But if it is the CJ, of course, then it's we've just seen how that process has
President and Council of State.
Exactly. So the second thing is that if the person is a CJ, and you even actually bring a petition not to remove them as a Supreme Court judge, you can't go and refer it back to the CJ for the CJ to make a decision whether he or she themselves have. So the truth is, even if you were making the claim against the person as a certain Supreme Court judge, you would, and the person is a CJ, you would still have to use a procedure for CJ. Now, for me, I would differentiate personally. Now, this one is my personal. So that's the constitutional architecture.
Sorry, say that again. Did you say if you are seeking to remove a Supreme Court judge, the procedure to be used will be that for the CJ?
No.
Okay.
I'm saying that if you brought a petition to remove the CJ in her capacity as a Supreme Court judge, you would still have to use the procedure for CJ because she's CJ.
All right.
You get what she's CJ, so you can't refer it back to herself to make a prima facie case and all of that. So I think for me, I wouldn't split heads over the grounds because they're the same, or the procedure because once the person is CJ, that's the only procedure you can use whether you are removing them as Supreme Court judge or CJ. What I would differentiate, and now this is my personal view, is that I would differentiate between whether it was it was related to the administrative role or it was under the grounds. Because if it is under the grounds, it's really splitting heads to say it. For me personally, for me, I've always, one of the things I believe in, which I've been talking about, is rules of procedure for Article 146, not just only for the CJ, but rules of procedure for all those who come under Article 146 removal, just for fairness and transparency and clarity. So at least everybody knows the procedure that they are going to follow, and then it takes place. Since we don't have time, that is what.
Rules of procedure have been asked for over the years, but they have not been made.
Yeah, unfortunately. And I don't have the power to make them. But yes, I would advocate that they be made.
So was at pains in a JHUM to say that it should be done and done immediately.
It's important.
And it's still not done.
We have rules of procedure for everything. So we have rules of procedure for the district court, we have rules of procedure for the high court, we have rules of procedure for the court of appeal, rules of procedure for the Supreme Court. Why not rules of procedure for Article 146 removals?
Over the years, they have been using...
We have rules of procedure for disciplinary hearing of the GLC.
Yes. Right. We need, I think the rules of procedure...
Over the years, they will adopt the CI 47. That's not good.
No, let's just make rules of, I don't know, let's just do the rules of procedure for Article 146 so that we know anybody coming under it, we know how the rules change. Why it is also important to have rules is that what the CJ is complaining about, that I didn't get A, B, C, D. So if there's a problem with the rules, we can amend them.
Okay.
So at least we can grow whilst we have rules.
Right. Mama Yarga says they are going to make rules now. Let's see what difference those rules will bring anyway. Dennis, do you share a different view? The Constitution says that to become a justice of the Supreme Court or the Superior Court, or even a judge, you must be a person of high moral character and proving integrity. High moral character and proving integrity. And to lose that job, you must have been found to have conducted yourself, stated misbehavior, or incompetence, or infirmity of body or mind, and so on and so forth.
So I think that when it comes to issues like this, nobody should assume any role or responsibility that the law doesn't give you. I believe that we need to be a bit more fair to the Chief Justice. At this point, after whatever the government wanted to do, they've done, I think it's time for us to calm down and begin to give her some hearing. I have always had a problem with the basis for a removal and all the things they went through. I mean, first of all, I think that there is no audit report from any auditor general indicating the primary, allegation they used against her. And I don't think our laws allow any other committee or body to determine these things other than the auditor general. I am very sure that when this government eventually leaves office and this woman gets an opportunity to go through this process again, we'll see a lot of gaps. But it's okay. For now,
it's not only the financial impropriety
most of them,
that was used.
Most of them. I mean, for now,
according to the outcome and the letter that communicated her removal,
I agree.
She was also found.
As it stands now, nobody has even seen the report. Okay. Even she herself has not received a copy of the report from the president. The only thing she's received is a letter from the secretary indicating that she's been removed.
That's precedent.
I'm just saying that as of now, she hasn't received it. So we don't even know. We don't even know in proper terms the basis for a removal other than what the president has stated. That's what I'm saying. When this government eventually leaves in 2029, we will know the details. That notwithstanding, I just want to ask. I know if I'm a judge, I'm supposed to live above reproach. So I am caught for stealing, and I'm dealt with according to stealing, which is misbehavior. The law doesn't say that automatically I cease to be a judge. The law says that I must be taken through a certain process, and then I'll be removed as a judge. Is that the case? Then if that is the case, there's a process to remove a Chief Justice, which you've gone through it with me. There's a process to remove a judge of the Supreme Court. It is only fair that and proper that you take the basis and whatever ruling, whatever evidence here, and take it through the process of removing a Supreme Court judge. And that is what I think the lady is looking for, basically. At this point, what we are doing is that we are saying that because we found you guilty on one thing, automatically you won't qualify for this. But here we are, and we are all clear in our minds that the person is saying, I wasn't even given a fair trial through this committee. So if she goes through the process of removal of a Supreme Court judge, she may adduce further evidence to, clear herself for certain things that have been made against her. But to say that because the processes of a removal of a Chief Justice have been seen through, and for that reason she has been removed, automatically she ceases to be a judge, is to say that if a judge is found guilty on a crime, automatically that judge ceases to be a judge. When the Constitution or the law itself has given a process that you should take a judge through before they are removed.
Have you tried to look at what the difference is about the procedure for removing a Superior Court judge and the procedure for removing a Chief Justice?
The simplest, one of the basic differences I've realized is that if you're going to remove a Supreme Court judge, the Chief Justice handles that, right?
What do you mean by handles that?
It goes to the Chief Justice. Now, if you look at the
goes
committee,
to the President.
Of course, and the Chief Justice.
The petition will go to the President. The President will send it to the Chief Justice.
Yes.
Then the Chief Justice will determine whether there's a case to answer or not.
In this case, the committee, actually the membership of the committee, as to whether they have the jurisdiction to remove a judge of a Supreme Court, it's another question. So the fact that the membership of that committee, the membership of that committee, do they have proper jurisdiction to remove a judge of the Supreme Court?
Membership of the committee or the committee?
No. The committee
that was set up.
That committee has jurisdiction over determining the fate of a Chief Justice. But do they have the jurisdiction over determining the fate of a Supreme Court judge? If they don't, then all you have to do is take whatever it is that they have done, which is now evidence of whatever crime the Chief Justice may have caused, and take her through the process of removing her as a Supreme Court judge and allow her to defend herself.
Okay,
that is the law.
So the Constitution says, I'm coming. The Constitution says, as a Supreme Court judge, or as a Superior Court judge, or as a judge, the only time you may be removed is that you have been found on these grounds: stated misbehavior, incompetence, or inability to perform the functions of your office arising from infirmity of body or mind. Are you saying that if, in this case, having been found guilty of stated misbehavior over financial impropriety, over attempt to appoint extra Supreme Court judges, etc., it can only remove you as a Chief Justice, but not as a Supreme Court judge, regardless that the verdict is that you have been found guilty of stated misbehavior?
That is why I said that. The 1462 is clear. It says that may only be removed by the procedure.
That's
so
1461.
No, 2. I'm referring to 1462.
Okay.
Yes, I'm referring to 1462. May be removed
in accordance
by the procedure. And if you may, I can even read it. It's 146.
A justice of the Superior Court of Judicature or a chairman of a regional tribunal may only be removed in accordance with the procedure specified in this article.
The procedures are not the same. The procedures for removing the Chief Justice is not the same as the procedure for removing a judge of the Superior Court.
And the only difference, as you have indicated, first and foremost, is that...
Like, I think that is primary. That, for example, on this committee were 2 other Superior Court judges. When you are removing a Chief Justice, would these 2 other Superior Court judges be there? Would Domelevo be there?
Okay, so let's look at it. If you are removing a Superior Court judge, clause 4, where the Chief Justice decides that there is a prima facie case, he shall set up a committee comprising of 3 justices of the Supreme Court, or chairman of the regional tribunals, or both.
Which one are you reading, please?
Clause 4.
Okay.
1464.
Appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Yes.
So the first difference is that to remove a justice of the Superior Court, Chief Justice will make a prima facie case.
Yes.
And after that, the Chief Justice, together with the Judicial Council, will appoint the members who will form the panel. Then clause 6, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So the appointment of the committee to do the process is done by the President with the Council of State.
For Chief Justice
and
removal.
prima facie is also done by the President with the
For
Council
Chief
of
Justice
State.
removal.
This is the difference.
For Chief Justice removal.
That's right.
But for the removal of a judge of the Supreme Court, a committee should be set up by the Chief Justice, not the President.
With the Judicial Council.
Yes, not the President.
Right.
Secondly, I made a fundamental point. I think that's what we should all use our mind to. Let's say I'm a Supreme Court judge, and then I'm found to be beating my wife. And so my wife takes me to, is it Dofsu? And Dofsu takes me through all processes. And I'm found to be domestic violence. It doesn't automatically disarm me from being a judge of the Supreme Court.
That's correct.
But somebody can, based on that ruling, now petition the Chief Justice and say, this judge,
petition the President.
The President, and say, this judge is a woman beater. I don't know why you allow a woman beater to sit as a judge in this country. The President may now write to the Chief Justice. When the Chief Justice receives that petition, he will check whether me beating my wife, for whatever reason,
It's stated misbehavior.
and it even affects or impairs my ability to be a judge. If he establishes that, then he will set up a committee for me to come and defend myself. Now that committee's evidence against me will be that ruling against me being a woman beater.
That's right.
I have to prove to that committee that the fact that I beat my wife in the past doesn't mean that necessarily I cannot execute my function as a judge. You may disagree with this, but this is the law.
The standard is
law.
that you are a person of high moral character and proven
yes,
integrity.
but the law says that she may only. So there is only one procedure. You cannot imply any other procedure.
Okay.
So you may have a very solid ground for thinking that she cannot be a judge. But the law says that you cannot use that procedure of removing a Chief Justice, which is for the 6.
Okay.
To remove a judge, which is for
let me ask
the
you this, and I move on to Roxy. Hold on.
So what I think anybody should do, now is to simply, like they did for this one, get one of their guys again to write a petition against the woman.
Oh, please.
And take it.
We ayan sama horo timi koso channel so mamra so jemre awhara sene so wade dia dumbi adomiania oni yamon rem yan sen so kwanson ko sukra aha age politics avenue.